Hi, I'm attorney Jack Inman, and today I want to talk about the process to establish paternity in the state of Tennessee. So, in the state of Tennessee, if your child was born outside of wedlock, that means you and the mom were not married, then that child is presumed to be in the custody of the mother alone. You, as the father, don't have any custody rights until you do two things. First is establish paternity, second is to set up a parenting plan. You have not accomplished those two things. You don't have any custody rights, and you may not even have any legal rights whatsoever with that child. From the legal's perspective, you could be a complete stranger with regards to the court system as it pertains to that child. So, how do you go about solving that problem if you've had a child out of wedlock? Well, first, you need to file a petition that does those two things, right? It should establish paternity. So that's asking the court to issue an order stating that you are 100% the legal father, no questions asked. And two, you need to set up a parenting plan so that you have a visitation schedule with that child. Now, how do you go about doing that? Well, that's something that we as attorneys can help you with. We do the entire process for you. We do all the paperwork and we get that through the court system so that you can have visitation rights and so that the mother can't yank the kid out of your house whenever she wants. Practically speaking, that looks like we file a bunch of documents, a big stack of documents that has both of those two things on it, right? The petition to establish paternity and custody paperwork setting up your visitation schedule. Then we go to court. The first court date typically looks like something to the effect of you're standing there, the mother's standing there, we're there as your counsel, and the judge is going to be looking at you guys and saying, ma'am, is there any question that he's the father? And if the mom says, under oath, Judge, I know he's the father. I don't need a DNA test. There's no question. I swear under oath that he is the biological father of the child or children at issue. Then the judge is going to look at you and say, sir, is there any question that you're the father? And if you swear under oath, yes, I'm dad, I don't need a DNA test, yada, 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 the judge right then and there can issue an order establishing paternity. You don't have to do a DNA test if both parties swear under oath that you're dad. There's some other exceptions as well. Maybe if you sign the birth certificate and the voluntary acknowledgement of paternity. That being said, judges still want to see a DNA test if there's any question that you're not the father. So if either party, that's you or the mom, say, I don't know if he's dad, I'd like a DNA test, boom, the inquiry stops right there. The judge is going to order you to do a DNA test to prove that you are the biological father. And there's really nothing you can do to argue your way out of that one in most cases. So once that's done, the next step is the court's probably going to order you to go to mediation, which is where you'll be in one room with me as your attorney. The other party will be in another room with her attorney, and a mediator is going to go back and forth to try to work out a parenting plan that you guys can live with. Is that always successful? No, but courts do require that you go through mediation before you go back and have a final trial in almost every single case. So be prepared to go to mediation. Again, you don't have to walk out of mediation with agreement. It's great if you can, but it's not required that you agree to something at mediation. You just have to go to mediation. If you cannot reach an agreement at mediation, the next step is you go back to court and you have a hearing, and the judge is going to tell you what your parenting plan is going to be. He's going to hear your side of the events. He's going to hear her side of the events and whatever witnesses you guys bring to court. And he's going to hear argument of counsel and maybe some briefs that have been filed. And he's going to make a decision as to what your parenting plan is going to look like. Now, in Tennessee, courts are supposed to maximize the parenting time of both parents, subject to a whole bunch of factors. So that means, generally speaking, most judges interpret that as a 50-50 plan is the starting place. And then you have to convince the judge why 50-50 is not appropriate. If you're a stranger to the child and you've never been in this child's life and this is your first time really having any interaction with the kid, 50-50 may be a far cry. You may not get 50-50 the first round. But if you've been involved in this child's life and your work schedule allows for 50-50 custody, that should be your goal unless there's some other factor that weighs against that. Now, if this was helpful or if you need any kind of assistance walking through this process, give my office a call. We service the entire Tri-Cities area, and we help dads who are trying to establish paternity all the time. Judges are used to seeing that, and as long as you get the proper paperwork in front of them and you follow the proper procedure, it is not as cumbersome as a process as you might think. My number is 423-777-8396. Give my office a call, and I'd be happy to talk with you to see if this is something that we can help you with. Hope to see you soon.